Hello and welcome to the Auditing Antics podcast. So today we have a good friend and a colleague of mine on, Ron Chapman II. And Ron, for those of you that are not familiar, which I think a lot of people know you, Ron, but you have a pretty impressive background. You're a federal criminal defense attorney and among other things as well. But that's where I've done a lot of work with you and our collaborations recently through Safe Harbor, which has been great. And, Ron, one of the things that I really appreciate about you and the work you're doing is that, yes, you do see that worst case scenario quite a bit where you're having to go in and defend, but you're really working hard in the industry right now to also prevent things and try to help people before it gets to that point. So I really appreciate that, and I'm excited to have you on today.
Well, thank you for having me. And yeah, for those who don't know me, I'm a federal criminal defense attorney. I spent my first part of my career in the Marine Corps as a prosecutor and defense attorney, and then came out and found that medicine was a very important place for me to be, protecting people from some of the impacts of government intrusion. I've spent a lot of time in federal court litigating cases and helping providers gain acquittals and minimize the risk. And yeah, because of that, it's just like Stephanie said, my focus now has turned to, well, in addition, is now helping people with the lessons that I've learned from the courtroom, looping that back into your compliance program so that you can stay out of trouble in the first place. One of the things that bothers me, and this happened during the Bothra case, I think a 52 count indictment that we won against a doctor, is that every day he was carted to the courtroom in chains because they didn't like the way that his practice billed for back injections, right? Nobody was hurt. Nobody complained. They didn't like the way he billed. 3 years of his life, basically, in jail and custody, and we got him acquitted. So winning a trial is great, but a quiet resolution through good compliance is what we like to achieve for those people who come to us early.
Yeah, definitely. Well,
Mhm.
and we're seeing a lot of that right now related to wound care. And, we've had so many clients coming in. It feels like for weeks now, there's just been new clients every week, sometimes every day. And, it's a new area of attack, right? So
Mhm.
our physicians and practitioners that are using skin substitutes, they're very expensive. And, that is one of the main reasons, if not the top reason, that that's being targeted right now. And, to your point, what you were just saying with Bothra, we're coming across many physicians who care a lot about their patients. And this has been the answer to a lot of the lack of care that they've had up to that point. Or even just conservative measures just not working at all for
Yeah.
them. And having that discussion between moving forward with skin substitutes or moving forward with an amputation, that's going to take a lot out, not only on the patient, but then these physicians that are working hard to do the best they can for their patient. They want to heal them. That's
Yeah.
their main goal.
That's that's it. I mean, I can tell you a real story related to that. There's a $1 billion wound care case that was indicted in Arizona. Now, all of you are probably listening know a lot about the technical side of auditing, right? And what is required of the government to do on the audit side. Well, that same thing doesn't reign true on the criminal side. So you would expect that when the government took down a wound care company and put the owner of it in jail, alleging $1 billion in fraud, that you would have had an audit, a high sustained error rate based on the products that were applied, a medical necessity determination by an expert, and at least that number would be tied to a specific value of fraudulent claims after an analysis was done as required by Medicare. Um, I am involved in the case and can't talk too much about what I did, but let's just say I sat down in front of the prosecutors on behalf of my client and said, I imagine you did that analysis, so where is it? There was no analysis, no medical necessity determination on a case by case basis. And I was telling a client the other day that the difference between providing too much health care and the difference between providing too much health care and fraudulent health care is a claim-by-claim analysis to determine that something is not medically necessary. That's the difference. Otherwise, it's just healthcare, right?
Yeah.
And that's a position that we have to continue to take with the government. And that's what we're seeing in a lot of these wound care cases: arbitrary denials, arbitrary indictments, arbitrary demands. And it's getting crazy out there. Of course, I'm sure we're going to get to the Medicare fee schedule change. But after doing all of that, now we see that they're going to cut the rate almost arbitrarily by 90% with absolutely no market study to see if the market can support it. I mean, the pain that is going to be experienced by the community who needs this care, if this goes through, is going to be tremendous. And for this not to have been done, fully promulgated through the right entity, to not be an act of Congress, is just absolutely astounding to me. I hate to get on my soapbox, but it's crazy.
Well, it's frustrating, and I experience those emotions when we're talking to the physicians we're working with right now, because like I said, we know that this is working, and they don't care if it's working. They care about the dollars. And we had a physician, for example, that we're helping, and he was describing one patient who, yes, in a claim you can have over $100,000 just because of how expensive these products are. But that patient had been dealing with his wound for over 2 years, and if this didn't
Yeah.
work, yes, he would have gone towards amputation.
Mhm.
So it's like, it's that catch-22 where they're not thinking of people individually. They're just looking at the pocketbook. But
Yep.
we know as well, Ron, there's a lot that happens behind the scenes too. Because, one thing that stood out to me in the final rule update that CMS just announced is that they're talking about the growth that they've seen in the numbers. And
Mhm.
if we look behind those numbers, you and I also know that there are suppliers, distributors, manufacturers.
Yep.
There's all these people in the background who are making quite a bit of money.
Mhm.
And for me, one of the things I get frustrated with in our work is that the physicians are on the hook at the time, but then we have all these other people who pushed it, made their money, told their story, sold the
Yeah.
product,
Yep.
regardless of the outcome.
Yep.
And it's hard to see people that are having to go through this right now when they thought they checked all the boxes.
Yeah, this is such a blind action by Medicare because of exactly what you just said. When they've decided to reimburse these as incident two, essentially, right? I mean, that was
Mhm.
the big change that they announced. And basically that means that they're treating it just like the Band-Aids and syringes, right? That you might have around the office. And of course, this is anything but that. Like, this is more important than a DME product, but it doesn't get the same sort of treatment. So they've decided to do that. But what they don't understand is the thing that is hurting the physicians right now is the question: if I purchase these supplies, am I going to be able to get reimbursed for it? Because there's a lot of physicians that have done that. They've, in good faith, in furtherance of treatment of their patients, have purchased supplies so that they can treat patients. They conduct the service, they don't get reimbursement, and now you've got the manufacturer coming at them, or the supplier coming at them, the rep coming at them. You've got Medicare coming at them, and then everything just gets squeezed down onto their level. The better way to have done this is, if Medicare has an issue with the cost associated with these products, and they want to change the cost that's associated with these products, then they're going to have to do an appropriate study to determine what they're going to pay and make sure that they have the right medical necessity indicators present, what they're going to pay and what the industry could afford. Because what we're going to get right now is exactly what one prosecutor tried to describe to me, which is just such a terrible scenario. She said, we've got patients of your client who are in hospice, who are receiving very expensive wound care skin substitutes. These aren't the types of people that should be receiving this type of care. And I said, oh my gosh, that is I may not have said, oh my gosh, I might have said something else, but that is the most cruel thing I have ever heard in my entire life. Yes, somebody is in hospice, but yes, they're in pain. Yes, they need appropriate treatment. And just because you're in hospice doesn't mean we should treat you like you don't matter. And that was just a tragic thing that I heard from a prosecutor's mouth. And that makes me wonder, what's going on up there at Medicare? Are they starting to say that just because these are mostly used on older patients, we need to cut reimbursement because they don't matter so much? That starts to look like some of the death panels that we were very concerned about previously, that we were assured when Obamacare was passed was not going to happen. And it's alarming.
Mm-hmm. Well, and through a lot of these UPICs, so right now we're seeing a lot of these audits and investigations through Clarent and Safeguard. They're the larger entities. And, you know, all of these audits we have coming back, they're all saying medical necessity, which,
Mm-hmm.
and I should clarify, medical necessity is the reason why they're denying and they want the money back. And, that's something that is very subjective. There's not really a good way to pinpoint that. And for me as an auditor, when I see that in an audit determination, I will look in and say, okay, what is the documentation showing me? What
Yeah.
is the backstory we have on the patient? And, that's a big thing too. For me, it's very important as a documentation and coding auditor to stay in my lane,
Yeah.
meaning that I'm not going to make clinical determinations. Medical necessity is definitely something that is clinical. So for me to say yes or no, I'm not saying it clinically, I'm saying, can I see it in the note? And, most
Yep.
of our clients, they have that proof there in documentation.
That's exactly right. Most of them are doing a fantastic job in documenting it. It's just that the needle keeps moving. I mean, it seems like Medicare over time has specifically avoided providing sufficient guidance to say this is exactly where the line is drawn. We've got different LCDs that are applicable. Some don't even have an LCD, and some have one, and in some cases the LCDs are conflicting. And then we've got private insurance guidelines that are obviously completely different from what Medicare has. And then we have Medicare continuing to kick the can down the road on exactly what they're looking to implement here. And so there's just all of these question marks. We have Medicare operating an area where they are causing uncertainty, and that's the last thing the industry needs when we've got patients who are suffering, patients who need real care, and doctors on the front lines who should be deciding whether or not these skin substitutes are going to be appropriate. I could probably complain about the problem for another 5 hours, but I imagine that what people are looking for when they see this fee schedule about to go into effect on January 1st is the answer to two questions. And the first is going to be, will it actually go into effect on January 1st? And what circumstances would cause it to go into effect? Because if it doesn't, right, then there's not this 90% cap and things sort of stay the same. But if it does go into effect, we've got big changes. The next question they're probably asking is, if it does go into effect, how are we going to get reimbursed? And how are we going to be able to continue maybe a business that has been created solely for wound care, primarily for wound care, which a lot of our clients have now specialized in wound care. A lot of the entities that we represent now solely do wound care because it has been an area that has been needed and a high growth area. So let's answer the first question, and feel free to jump in. I don't want to run too long, but I did want your people to hear this. The first question, will this stall? Well, this isn't going to be like the Ryan Height waivers for the DEA where it gets kicked down the road for like 3-4 years. I don't know how far we are. I think that ultimately something is going to be done. It was delayed, I believe, as a result of the Trump administration, probably because of some lobbying efforts to not allow it to go into effect. And around that time, I imagine that there was probably a significant amount of lobbying that basically caused that to stall out. We're not seeing that sort of pressure take hold as well. And we're also not seeing the fights in the federal courts that I would normally want to see to think that there's going to be an injunction preventing this to go into play. But just like you talked about right before the show, what really may happen is this does go into effect, and then courts don't like to offer relief before something hurts somebody. That's really hard to get. It's much easier to get when something happens and it actually does. So unless you can challenge the way that this rule goes into effect, you probably don't have a good fight before it goes into effect. But you have a really good fight after it goes into effect if you can show that patients aren't getting care, that businesses are put out of business, and that there is an arbitrary cap on the price. And where I think that the big thrust of the challenges will be is the approved versus non-approved reimbursement rate, because we are going to see unapproved skin substitute products, even pending approval, absolutely get obliterated if this rule goes into effect, because the reimbursement is going to be appropriate for those that are approved by the FDA, and it will be inappropriate, it will be not sufficient for those that are unapproved. So those businesses will shutter, and they've got no choice but to litigate. They will run to the courts, and hopefully I'll be with them, and fight like hell to try to get this stopped. They may be able to get an injunction preventing the rule from going into effect, or at least carving out that difference between approved and unapproved. And if that works, then they may see the reimbursement rates stay where they are.
Well, and I want to talk a little bit as well. Sorry, one second. I think we've got a echo.
Oh, a question? Oh, an echo?
Yeah. So I want to talk some as well about the LCD policies and, what we've seen as far as the behavior. And what I mean by that is a couple of things. You had mentioned that some people don't have an LCD in place, and then others do. So we're seeing a mix there as far as requirements go.
Yep.
And then, you and I, in talking to mutual clients, we've now seen that there's issues with the behavior of these entities, meaning, the IRS showing up at a practice or patients being interviewed. And can you speak a little to that? From my perspective, I'm looking at this as something where they're frustrated at the government.
Yeah.
And I know, for example, when cases have gone to the ALJ, they've been successful and been overturned. So I feel like they're grasping at a lot of straws right now, trying to figure out how to keep this money, and it's not working. So they just keep trying other avenues.
Yeah, that's exactly it. So when the government doesn't have a great argument for doing what it's doing, and it doesn't have a good framework, sometimes it will just frustrate you in the administrative process so that it can slow down spending or slow down the behavior. And I think it's wrongful. But what the reality is that a lot of providers who are faced with these sorts of audits will crumble, right? They'll provide insufficient documentation. They won't go see Stephanie Allard, who will get them looking sharp before they submit it. They'll try to do it on their own, or God forbid, they're going to have and I love all the billers in the world. I love them, but they'll have their biller do it. And oftentimes the biller is not as well connected with the healthcare delivery side, so they don't capture everything, right? That's not the best use of it. If you are getting audited in the wound care industry, you've got to get a dedicated compliance entity, because you need to brush up on your compliance first to make sure that the future looks good for you, but also make sure that what you're submitting is going to be good. So they're engaging in these audits, and that's the first place that they're going to filter you out, right? You might just pay it back, because a lot of providers tell me, I don't know that I want to fight. They're going to come after me. That's unfortunately the wrong mentality, but an understandable mentality. I completely understand not wanting to pick a fight with the government. The reality is that you need to start that fight so that you can get in line. To get your ultimate reimbursement and not trap yourself. The other reason you need to start that fight is that once you pay this back, or once you crumble on this issue, the first 5 charts, we know they're going to ask for the next 40 charts. And then later on, they're going to ask for the next 100 charts. And next thing you know, you could be looking at being one of those $1 billion healthcare fraud providers, because they've decided to ratchet the numbers up and they didn't do a medical necessity evaluation. So that's the first way they try to filter people out of the process. They hope you don't get represented, and they hope that you just crumble and they've saved money for the Medicare program, right? That's the first way. The second way that they try to filter you out is, even if you do fight a little bit, the administrative process is a very long process, and a lot of businesses have trouble surviving during that process, right? So they try to crumble you during that process. And then the third way is they're going to take, and this is actually what federal prosecutors do, they're going to take the total amount of reimbursement that certain entities receive for like wound care skin substitutes, and they're going to say, these are the top 5 providers. well, these people must be committing fraud because their numbers are so high, right? And I've met a whole bunch of people who are considered the top one provider. It's just the way that you make the numbers look, right? When I was doing a lot of opiate cases, there were like 3 people in the state of Kentucky I represented who were alleged to be the #1 prescriber of opiates in Kentucky. It's just how they bend the numbers. But so they look for the top, and then they take a big, solid indictment swing at those folks in the hope that everybody else sees that and they keep their head down. They don't respond to that audit. They don't fight at the ALJ hearing because they're afraid of the handcuffs and the press and they don't want to look like that person, right? So this is a combined approach. Now, what's the solution to solve that? Well, we handle you every step of the way. If you're getting an audit, it's a cost of doing business. Get compliance, get help. If it goes to the ALJ, get a lawyer to back you up. God forbid the government wants to try to indict you. You put on a case, right? You don't just say, oops, you got me, right? And plead guilty and accept 15 years in jail. That's not what we want for anybody. And that's certainly not what I want for my clients. So I call it bureaucratic malice. It's not necessarily there's one person at the top of this going, we want to take everybody down. It's just there are a lot of people motivated by saving money for the Medicare program. And the way that they save money is by targeting the people that will usually get them a lot more money back for the program. And then they get a really nice pat on the back. Congratulations, you saved Medicare a whole bunch. How many patients did you kill? We don't know because we don't count that, right? But you saved Medicare a whole bunch of money. And that's why it happens. That's this bureaucratic malice.
Yeah. Now we have a question here. UPIC told my client that the skin substitute she was using was experimental. Have you heard this? And, we hear this all the time. This goes back to that medical necessity, the FDA status. So you were talking about 351 versus 361. And to give a little context to that too, when we're looking at the difference from the FDA level, what they're referring to there is their steps that someone has to go through. So when there is something that's 351 approved, that means that it's gone through a much more rigorous process. And often they're looking pre-market and post-market at that. And, when we have things that are, I see a lot of times we're on 510K cleared, for example, that's showing that they think to some extent that that is pretty safe and there's not a lot of risk and they think it's going to work.
Yep. That's right. Right now, based on the fee schedule, the designation will be approved or unapproved. That's the line that is going to be drawn. I think, if I recall correctly, the LCDs have some mention of experimental, but I think that really the category is going to be whether or not it's approved or unapproved. If they're suggesting that it's experimental, then it obviously is a play to try to limit the reimbursement because this skin substitute should not be applied. Fair, but LCDs aren't law, right? And when we look at the FDA, those statutes that we talked about, FDA approved or not approved, absolutely law, and those categories are certainly valid. The problem here is that we have a changed reimbursement based on your FDA approval status, regardless of whether or not you are in the approval process, right? So we're basically going to have a freezing of approved skin substitutes because nobody else can get off the ground if your reimbursement is so low when you're unapproved. And nobody will be able to get the funding pre-market to go through this rigorous process. It seems to me like those entities that have approved skin substitutes that have already been approved are probably just like clapping at Medicare, just really happy at what's happened. And all of the unapproved people are like, we really want to join the cool club. But the approved people are saying, no, we've just cornered the market. I mean, I got to wonder, does that look a little bit like maybe some cronyism happened there? And maybe they've just decided to say, it doesn't matter how good your product is. We're not going to reimburse you until we've decided that you're approved. That's kind of crazy. But yeah, to answer the question, yes, I've heard the experimental phrase has been used. You also have to watch out for suppliers and distributors and reps who get very close to misrepresenting the approval status. That's going to continue to happen, right? I mean, Stephanie, you and I had a conversation a while ago. I won't get into that too much because that was related to a client. But the upshot of that conversation is some reps are saying some things that might confuse doctors into believing that these things are approved. We are actually at Safe Harbor in the process, and Stephanie's helping a lot with this, in developing an approval list, because I couldn't really find one that listed all the products, so that we can advise folks on the approval and the reimbursement methodology, and even use that to help you run some calculations in your practice so that you can see what it looks like.
Yeah, definitely. All right, another question here is CMS issued a comment period on this as with the ops. So I have not looked too much into the comment period related to this. I know I've been following the LCDs because the different states and regions that don't necessarily have an active LCD are looking to implement, but just as an article right now, not an LCD.
Yeah, so if they're talking about the fee schedule, the final rule, I believe it's already been approved. At least that's what my research indicates. Yeah, I don't know if there was a comment period. I mean, there should have been, according to the Administrative Procedures Act, but I don't know. There is a law, and there's a Supreme Court case, as well as federal guidance, that says that if it's not properly promulgated, if a rule is not properly promulgated, according to the Administrative Procedures Act, that it can't have the force and effect of law. But that doesn't prevent it from being used as payment guidance. So what that might mean is that you can still use the products. It's just the guidance will be similar to an LCD, that it's not going to be reimbursed at a different rate. It's going to be reimbursed consistent with the rule.
Yeah. Now, going forward, I know a lot of people are, probably feeling uncertain as to how they're going to handle all of this. And, even people who are actively going through these audits and investigations, especially with the UPICs. And I want to talk a little bit about what next steps should be for those practices. You and I, Ron, through Safe Harbor and then through your law firm, are working with someone who came to you when they're already at that level of the ALJ.
Yep.
And, I don't think we can stress enough how important it is for people to come forward right away. As soon as you receive any kind of notification that they're asking for documents, that is the time to ask for help.
Yeah, that's right. It's much harder the further you are in the process for me to be able to assist. I certainly can, right? You can come to me. Somebody just came to me a week before their trial. You can do that, right? And I can still probably help you out, but the things that I'll have in my toolkit are going to be a lot less. And the mistakes that might have been made, I've got to live with. So if there were no mistakes and you were working with the best people, I might be in a very good position. But if there were a lot of mistakes, there usually are, and you weren't working with the best people, sometimes that happens. We're really prejudiced. The thing that I want to stress here, and the reason why I created Safe Harbor Group, and why I'm so proud of what the work that the professionals like you at Safe Harbor Group have been doing and assisting us with, is that this team was created because the healthcare industry, as you know, is incredibly fragmented, and the services that are offered by healthcare compliance professionals are incredibly fragmented. And there really isn't a one-size-fits-all approach, but you need somebody who can be with you from the beginning to the end. From that initial audit request, somebody that you can just pick up the phone and call or send that email to, all the way to the ALJ side of things, and you can get the support of a lawyer in the process. Look, if you've got a lawyer that's really close to you, that's really good, but does that lawyer know all of the things that these talented and dedicated compliance professionals know? Absolutely not. There are things that Stephanie knows that her knowledge is way deeper than mine in the healthcare industry, but I do know the law, and I do know the people that I need to assist a client. And so that's what we're seeing in the wound care industry that is a big problem. First, we have venture capital. Venture capital hasn't allocated a lot of its budget to compliance historically. Some have, and I applaud those who do, but often it's like, hey, we've been in regulated industries before. We can navigate this. Healthcare is a little different, right? It's not that easy. But if it's not venture capital, often we have providers who change specialty and they decide to get into an area where they don't spend a lot of time. They have to trust a biller. They have to trust additional staff. They start making a lot of money. They don't reinvest that into the compliance program. They get in over their head. I've seen that story happen time and time again. Then you also have this kind of third issue, the very compassionate provider who wants to help and doesn't spend as much time with their nose in the rule book because they're focused on patient care. You don't know what you don't know, and you get yourself into a lot of trouble. And those three positions are completely understandable. Venture capital and business doesn't know all about healthcare compliance. Providers are spending time with their patients and don't spend their time studying compliance. And that's one of the reasons why, you've just got to get somebody to help you out. And that's one of the reasons why Medicare really wants to get you to go with the compliance professionals. With the ALJ proceeding specifically and wound care, what's really important here is the initial documentation that's provided. If the initial documentation is bad, if the initial documentation is just simply unsatisfactory, in the words of some of my favorite Southern colleagues, you can't put lipstick on a pig, right? You just can't do it. And no matter how hard I try, I may be limited in my response. So that's why it's vital right at that beginning stage to get the help that you need.
Yeah, definitely.
Yeah.
And, going forward, if you are in this space, you need to know what's going on, not just with this final rule, but, I was talking about the LCDs, the proposed LCDs, the articles. One thing that I say sometimes that surprises clients is that even though they may be in a region that doesn't have an LCD, I, as an auditor, still want to look at it with that lens because I don't want to be blindsided by anything that may come back from that UPIC. And, we've seen one MAC use another MAC's guidance against each other. And, obviously then, Ron, you come in from the legal side and take over with that argument. But it happens and we have to be prepared. We want to make sure that we're doing everything we can to put that best foot forward.
Yep, that's exactly right. And the reason why your approach is so important is because by the time I can make an argument that the medical necessity standard that they're using is inappropriate, by the time I actually get to make that argument, it is often way too late, right? You've had payments frozen. They're recouping from you. You might have a bill of $2 million. And now I'm standing before an ALJ saying that this is inappropriate. I would much rather have just tightened you up in the beginning and we play to the highest standard available. That used to be Medicare. They used to be able to give us a standard and we could play to it. It was pretty easy, right? Now things are getting a little bit more confusing, but that's what we do. We look for the highest standards available and we try to get our clients in line with the highest standards available. And that's what you should all do if you have any wound care practices or really any other type of area. Command your field, know what you do it well, and make sure you play to the highest set of standards you can find.
Yeah. And I'll make sure in the show notes today that I'll put links to your law firm, Ron, and then also Safe Harbor. Lori at Safe Harbor can help as well as far as contact and getting things coordinated for us. She's great with that. But, you don't want to go through this alone. And, we've had clients who've never been through this before in their entire career and they're sick over it, losing sleep over it. It's like, don't put yourself through that. It's not the end all be all when you get these letters and these notices.
Yep, that's right. That's right. We often want to do so much ourselves just because it's hard to trust, the right people to do it. And I find that's the case often with compliance. We want to take it on, but that's just a really difficult thing to do. There is something that I think might be able to help folks out there that we're looking at doing. You've worked with Jordan for a while, and obviously Safe Harbor is getting deep into the data analytics for a lot of clients because it's been very helpful on the litigation side, but it's also going to be very helpful on the revenue cycle side, specifically with respect to wound care and skin substitutes and different vendors and suppliers. So to answer that second question that I posed earlier, what's going to happen to the businesses and the reimbursement? if this rule change goes through, we are going to be able to run models and projections for folks so that you can really understand what the reimbursement is going to look like in the future. And we can do that and even provide a dashboard for folks that will allow them to see what their reimbursement is looking like for some future planning for the business. And that'll help people make some better decisions as to whether or not continuing with a wound care based practice is going to be the right decision for them.
Yeah, especially when that's everything they're doing, for sure.
Yep, that's right. That's right.
All right. Well, Ron, I thank you so much for coming on. I really have been thinking about this a lot and our clients a lot, and really been wanting to get this information out here publicly. So I thank you for helping me do that. And, I know this is what we work in every day, but a lot of people tend to be blindsided and not really paying close enough attention.
Yeah, no, that's right. Well, thank you for the opportunity. I love the opportunity to get out there and chat healthcare and in a way that folks on the front lines can hear it and hopefully get something out of it. So if anybody has any questions, feel free, check us out at safehg.com. And Lori can certainly hook us up with a meeting so that we can answer anybody's questions and help you out. And then I anticipate having a little bit more of a detailed assessment of the rule change on the SafeHG website. And Stephanie, I'll make sure that you're tagged in that so that you can get it out to folks. But that'll have, for those people who really want to do the research and read through the Federal Register and get kind of geeky on it like I do, we'll have all that information down there for you.
Okay, great. All right. Well, thank you for joining, and I hope to see you all next week.